All right, I think we're live. And all right. So we'll see. Is anyone here yet? So I'm excited. Okay, yeah, we do have some people here. Great. So this is going to be an interesting discussion today. I've got about an hour and a half. For those of you who are on Clubhouse, I'm also streaming this to Clubhouse, which is why I've got my AirPods in. No legal advice, obviously, today. Big disclaimer. I always have to give the disclaimer at the very beginning. I'm not providing legal advice. Nothing that I say on this call today should be considered legal advice. It's not really a call. It's a YouTube live. And just comment below and let me know if you can hear me okay. That would be great. I don't know where you're coming from. But comment below and let me know if you can hear me okay. I think there's a little bit of a delay between when I talk and when people can actually hear me. So I just want to make sure people can hear me. Let's see. And okay, great. Okay, good. You can hear me. So the title of today's call was YouTube and copyrights. And that's kind of what I'm going to be talking about. And I want to give a little bit of a background as to why I chose this topic for today and what I'm doing. So obviously I'm a lawyer. I work with online entrepreneurs. I help people with their LLCs. I help people with their trademarks. I help people with all sorts of things related to intellectual property. And I've obviously got this YouTube channel. Now, what I want to do and what I'm trying to do with the channel and everything else is I want to help entrepreneurs to learn more about the legal aspects of running their business. And the way I want to do that and the way I think I can reach a bigger, larger audience is bring more what a colleague of mine, Tim Schmoyer, I was in his course, said is bridge the known with the unknown, right? And so I want to use things like videos, or excuse me, movies, popular TV shows, news events, different things like that, to try and bridge that gap where I can look at what somebody's did in a movie and talk about it from the perspective of what if I was their lawyer. And hopefully by doing so, I'm going to, number one, reach a bigger audience, and number two, make it easier for people to understand the little nuances of how the legal system works when it comes to running an online business. But there's a problem, and this is why I've been hesitant to do this up until now. And the problem is that I was honestly scared of, number one, YouTube's content ID system, and then number two, of the possibility of getting a copyright strike on my channel. And so this is something that I'm sure a lot of you who are tuning in today can relate to. You want to do more with your channel. You want to take some artistic liberties, but you're just afraid that the content ID system might demonetize you, or you could get a copyright strike. And obviously we all know on YouTube, 3 copyright strikes and you're out. Your channel is banned. So if anyone can relate to what I'm talking about there, just leave a comment below and let me know. So I think that by changing the format of my videos to include more pop culture references, I can reach that broader audience, like I said, and I can really start to breathe some new life into my channel and attract some other people that still need this information in a way that's going to be hopefully helpful and entertaining. And if I don't do that, I mean, my channel will be fine. But I think that this is the way to really move forward. And Kim says definitely. So what I want to do today, and my hope for those of you that are attending today's YouTube live, I guess I've also got on Facebook, and like I said, I'm also doing this on Clubhouse, but I don't have any followers on Clubhouse really, so I don't know how many people will actually show up. But if you want to follow me on Clubhouse, just do a search for, I guess it's Jim. It's at Hawthorn Law is my handle on Clubhouse, so feel free to join us on Clubhouse as well. And if you have questions, if you join me on Clubhouse, I can bring you up on stage when I finish my presentation, and then you can actually ask them live, which I actually think I can do with this because I'm using StreamYard as well, but I'm not sure. So anyway, so what I want to do today is kind of in an effort to move my channel forward in a way that I would actually start doing more in terms of bringing in some pop culture references and things of that sort. I've been doing a lot of research and a lot of digging into copyright law, number one, fair use, and the content ID system on YouTube to try and figure out what I can and can't do, what I can get away with and what I can't get away with. And so I want to take a minute, and really what I want to try and do today, and then we'll open it up to some questions, is just kind of go through the process of what happens when somebody either makes a content ID claim, or what's the process in terms of if you were to get a copyright strike and how does that work. And my hope is that if you stay to the end with us today, you're going to have a better understanding of how this process works, and you're going to feel a little bit more empowered that you can create content that will, number one, not get you a copyright strike, and number two, that you will be able to monetize without fear that you're going to be subjected to content ID claims. So let's just go and do a little background here. So first, with regards to the content ID system, just in general, this is YouTube's automated copyright management system. That's the way the content ID system works. It scans videos for copyrighted material, and then it allows the copyright holder, also known as the rights holder, to claim it as their own rather than submitting what's called a takedown notice. And this came about because of a lawsuit that was filed back in, I think, 2007 or 2008, and where YouTube had been up to that point hosting pirated videos on the channel, and they were trying to find a way to resolve those issues. And so they came up with this content ID system. And so if you're a rights holder, if you own a video, whenever you post it to YouTube, YouTube knows that you own it. And then if somebody else tries to take portions of that video and put it into their video, then you'll be notified on the back end about that, and then you can actually claim that. And if they're monetizing the video, you can claim the income from that video. Now, on its face, this sounds like a great thing, and frankly, it's not. It is a good thing. It is good because it's walking that balance between protecting the copyright holder and at the same time trying to be fair to the creator. And here's the system they've developed with that. So if you, and I'll be honest, this happened to me just the other day. I haven't up until this point seen anyone take any of the content from any of my videos and put it in their videos, but I did see that this happened recently. And so I saw what it was like from the rights holder perspective, what it looks like. And so basically, if you're notified, if you have a channel and you get notified that somebody is using part of your video, that as a rights holder, you can do one of three things. You can either track the performance of the video, you can just leave it up, you can see how it performs and not do anything. You could block it, and you can actually do this on a country by country basis at this point. Or the third option is if the original, or if the creator is monetizing that video, you can claim it, and then you can monetize the video by placing your own ads on it, that would actually direct them back to your channel if you wanted. Now, so that's if you're the rights holder. Now, the nice thing about the content ID system is it does not carry with it a copyright strike, unlike a takedown notice, and we're going to get into that here in a minute. The content ID has no impact on your channel. There's no adverse impact, and there's no limit to the number of items or content ID claims that you can get on your channel. Basically, and I don't mean to be blunt here, but this is kind of the way I see it. This is a system that allows, for the most part, large corporations to profit off the back of creators without engaging in all the risks that are associated with a DMCA takedown notice. Now we're going to get into what a DMCA takedown is here in just a minute. So just stay with me. So, um, if you are the creator, and let's say you chose to do a reaction video. Now, all this assumes, before I get into this, all this assumes that you're making fair use of the material. If you're not making fair use of the material, then yes, you are going to have a problem. But if you are making fair use of the channel of the rights holders' work, then this is the way I would approach this, the getting a content ID. And I'm kind of putting these systems in place in the back end for me, because I know that at some point in the very near future, I'm going to be releasing videos that are I'm going to be using other people's content, and I don't want to, number one, I don't want to lose the AdSense revenue. Number two, I don't want to get a copyright strike. So I want to make sure I do this the right way. Now, so if you feel that you have a genuine basis to dispute that content ID claim, in other words, you're making fair use of the video, then the first thing I would do is just evaluate your video and say, am I actually making fair use? And if you are, then you can dispute the claim. And basically, the way this works is there's a little button inside the channel that allows you to dispute the claim, and then you're going to be asked to explain why you think that your video is fair use. Now, I watched a really great video, and you can find it on YouTube. That was Daryl Eves did. For those of you who know Daryl, he's another major. He's a YouTube coach. He helps brands and creators and everyone increase views and watch time to their channel and grow their channel. And he actually just recently released a really great book. You should check it out. I can't remember the name of it, and I don't have it off the top of my head. But if you search Daryl Eves on Amazon, I'm sure you can find it. So the first thing you're going to have to, so what I was saying is they did a really great video that where Daryl was interviewing Devin Stone. Now, Devin Stone is he's a lawyer. He's actually a copyright lawyer in a former life. Now he's a creator. He runs the channel Legal Eagle and puts out some great videos, and they're all reaction videos. He for the most part, he's reacting to what other people, to movies, the news, things like that. And his goal with his channel is to teach people, is to make the law accessible to more people. And so Daryl interviewed Devin and to talk to him about these exact issues. And what Devin said is that what he sees a lot of people do when they're responding to these disputes is they just put a one-word answer, like transformative or fair use or whatever. That just isn't going to cut it. And there actually is a great case that was done that went to the Southern District of New York. The H3H3 case, as it's been known, between Matt Hassanzada, if I'm saying that right, and Hilla and Ethan, I believe, Klein. And you can look that case up. It provides a lot of great language in there in that case about what you can do to talk about the factors related to fair use. But anyway, what Devin was saying in this video is to explain all the fair use factors and why your video may apply as fair use. And I just got my first person on my Clubhouse. So welcome, Jared. Jared, I'm also doing this on YouTube Live. So feel free to join us there too. So that's the first thing you're going to need to do. You're going to need to explain why you want to dispute the claim and why your video would actually comply with the factors for fair use and should be considered as fair use. So that's step number one. Now, what happens from there is the rights holder will get your response, and then they to the dispute, and here they have 30 days to respond to what you've done. And here's come up one of the things they can do. They can take one of really four different actions. The first thing they can do is they can release the claim. They can agree with you and say, okay, yeah, you're right. This is probably fair use. And so they can release the claim, and then that's it. You go on your merry way. They can do nothing. And if they don't do anything after 30 days, then the claim will expire and you don't need to do anything either. They can reinstate the claim, which is basically they're saying, I deny your request to release the claim, and they can reinstate it. Or they can take down your video, which would result in you getting a copyright strike. Oftentimes what will happen is they will reinstate the claim. And that keeps them within this content ID system on YouTube. Now, if they do that, then you are permitted to appeal that action. Okay, so that's not the end of the story. So you're permitted to appeal that action. Now, if you had ads running on the claimed video, the revenue from those ads will kind of be held by YouTube until they figure out how this claim is going to be resolved. And if you end up winning the claim, and winning is not really a great way to look at this, because there's no it doesn't seem to me, from looking at everything on YouTube's website, that there is no third party that is looking at these. It looks like this is YouTube is really serving more as a facilitator of this process. So you dispute the claim, YouTube sends the dispute to the rights holder. The rights holder decides how they want to respond to that. If they reinstate the claim, then you get to go ahead and file an appeal of that, which actually goes back to the rights holder to decide. And we'll talk about what options they have at that point as well. So, if you get to this process and then you appeal the claim, then you'll be given a place to respond, is my understanding. I couldn't find any screenshots of this, but you'll be given a place to respond to each of the fair use factors if you're claiming that the video was fair use. And you'd have to provide a substantive legal rationale for why your video is fair use. Obviously, it has to be factually accurate. It needs to be persuasively written. And you really need to consider writing this in a way that the person who's responding to this is going to take you seriously. If it's sloppily written, if it's incomplete sentences, if it's gibberish, then they're probably not going to take you seriously. But if you do a good job writing it, Devin talked about on his. And this was really empowering to me to hear him talk about this, because this is something I want to do. Said that for like every single one of his videos since he started doing reaction videos has been claimed, and he's disputed all of them. And he said in the video that he has won all of those. A lot of them went to appeals, and he still won almost all of those. Only one of them went to the next stage, he mentioned. Now, mind you, this video was from 2019, so things have changed a little bit since then. But anyway, so you go to the appeal stage at this point. And the copyright holder, again, has 30 days to respond to your appeal. And after you appeal, there are a few actions that the copyright owner can take. Again, they can do nothing and let the claim expire. So if they don't respond within 30 days, the claim on the video will expire, and you don't need to do anything either. They can release the claim, just like before. These are the two options they could do before. They can release the claim if they agree with the appeal, and you don't need to do anything. Or, and this is where it starts to get a little tricky. Now, they can't reinstate the claim at this point. But what they can do is they can request removal of your video. They can either schedule that, or they can ask for that to happen immediately. And this is what they do. This is kind of they're entering the area of the DMCA takedown at this point. And so they can either ask for that to happen immediately, in which case, if they provide that the legal information that YouTube requires and the DMCA notice requires, and they comply with all that, then the video would be taken down immediately and you would receive a copyright strike on your account. Or they can schedule a takedown request for your video. Excuse me, something in my mouth there. And if they can schedule this for 7 days out. And what that gives you the option to do is you can cancel the appeal within 7 days and you'll prevent the takedown. You won't get the copyright strike. But the content ID claim would remain active on your video. So this kind of gives you, in YouTube's mind, this is giving you another option to avoid getting a copyright strike, and but they would still have the content ID claim, and they would still be able to take all the money from your video. So that's the other option. So at that point, if you want to continue proceeding with this, if you really feel that your video is fair use and you want to move forward, then it goes to the DMC takedown stage. So YouTube has to, they're required by law to take down the video if as I mentioned, the DMCA notice is legally valid. And at that point, they will issue you a copyright strike and take down the video. This is where a lot of people get themselves into trouble because they freak out. They don't know what to do. They delete the video. But unfortunately, this does not resolve the copyright strike. And as I mentioned before at the beginning of the video, 3 copyright strikes and your channel is subject to being canceled. So you're done at that point. However, there's also legal repercussions that flow to the rights holders. And a lot of times these are either people that are going to go this far. It could be creators that, as in the case, I talked about the Hazen-Zaida versus Klein case earlier. Matt Hazen-Zaida was just a regular creator. He wasn't a record label. He wasn't a studio. And so oftentimes it's going to be a corporate entity at this point. And if it's a corporate entity, they're going to have done all their due diligence. They've got a lot of money behind them, and they can move forward with the process if they so choose. So this is why it gets a little scary. But there are repercussions to the rights holder by issuing a takedown notice, because here's the way this works. And YouTube doesn't come out and tell people this. It seems to me, in reading through all the information on YouTube's website about copyrights and strikes and content ID and DMCA, that YouTube is very much pro the big corporation. They're not pro creator. They don't really, they tell you what your rights are, but they don't really, they're not very clear about what your rights are. So and they don't let you know that you have more power than you actually think you do. So at the DMCA takedown stage, so this is after the appeal. If the rights holder says, you know what, I'm rejecting your appeal, we're going to go ahead and take down your video, they can either say, like I said, they can do that immediately or they can schedule it. And hold on a second. So as I mentioned, if they do the DMC takedown, there are repercussions that can flow to them. And they could be on the hook for attorney's fees if the creator actually pushes back against them. So here's the way, before I get into what you can do about this, just so you're aware. Well, let's just go through the whole step. So, and then I'll go back and explain why I think that this is, why most rights holders probably won't take this step, but they could. And the reason why is if you've done a good job of responding to the appeal and and you've done everything you need to do, and you've explained to them that you're serious about the fact that you believe your video is fair use and your video is actually fair use, here's why I don't think it's going to go much further than this. And that's because if they issue a takedown notice, now you have two options to get that copyright strike off your channel. You can either negotiate with them directly and try to get them to reinstate the video, and that would resolve the copyright strike, meaning it takes the copyright strike off your channel. Or you can issue what's called a counter notification. Now, if you go to the YouTube website and you look at the pages that talk about this, they almost caution people against doing this. And I have I suspect why this might be, but they caution people against doing these type of things, like doing the counter notification, because here's what happens: the stakes are getting higher now. At this point, your counter notification will be forwarded back to the rights holder, and now they have really only two options. They have 10 business days. This is what's written into the DMCA, the Digital Millennium Copyright Act law. They have 10 business days to reply to your counter notification, and they can do one of two things. Well, either they can not reply, and at which point your video would be reinstated and the copyright strike would go away, or they can let YouTube know that they've gone ahead and they've initiated a lawsuit, a copyright infringement lawsuit against you, to keep the content from being restored to YouTube. So they would have to actually go to federal court and file a copyright infringement claim against you. And then at that point, the strike would remain on your channel. The video would remain taken down until that lawsuit was resolved. Now, where I say this is a big deal, it's a big deal for a number of reasons, but here's the bottom line, really. To file a lawsuit in federal court for copyright infringement, you must have done a couple things. Number one, you have to register your copyright for that video first. Now, there is a fast track process to get those copyrights registered that can happen in about a week. But so that's a prerequisite. You have to get that copyright registered before you can actually file the lawsuit. You can't submit the application for registration. You have to actually get the registration back from the U.S. Copyright Office. For that to happen within 10 days, for most run-of-the-mill creators who have not registered all their videos with the Copyright Office, that's probably not going to happen. But for the larger companies, the larger corporations, the record labels, the music company, the music labels, the record companies, all those things, the studios, they will in all likelihood have registered their copyright. Now, the reason why well, number one, that's your ticket to get into federal court. But the other reason that that's important is if you register your copyright before the infringement, before the alleged infringement took place, then you're eligible for statutory damages and attorney's fees. Without that, you're not eligible for, as a plaintiff, you're not eligible for attorney's fees, and you'd have to prove your damages in court. So that's the first thing that you really need to understand there. The second thing you need to understand about this process is that if you are the defendant, in other words, you're the one that's claiming fair use, and you submitted a counter notification, if you are eligible for attorney's fees if you win the copyright lawsuit. And that's why this is such a big deal. And that's why the stakes are so high for the rights holder plaintiffs who may have to make a decision as to whether they're filing a lawsuit. They have to really look closely at your rationale, your video versus their video. And that's usually the analysis that's going to be done. Look at your video, look at their video, and decide, is this fair use or not? And if you don't want a judge to make that decision and risk costing yourself hundreds of thousands of dollars, because that's what these lawsuits cost, hundreds of thousands of dollars, then you're probably not going to file a lawsuit in federal court, which means at that point, the lawsuit will be, or the DMC will expire after 10 days, and then you win the content ID claim, you win the DMCA takedown, you don't get a copyright strike, and you go on your happy merry way. So, in terms of, I'm just going to stop right there. I've been talking for about 30 minutes straight on this process and how this works, and I'm just going to open it up. If people have questions, feel free to drop them in the comments, and let me know if this is making sense, or if you have questions about that. I'm happy to answer them. I'm going to take a quick sip of water. So again, I think there's a bit of a delay. And like I said, if you go to Clubhouse, if you're on Clubhouse and you want to ask your question publicly, you can join us in Clubhouse because we're there too. We're also on Facebook. So while I'm waiting for some questions to come in, if they come in, let's talk a little bit about fair use and what that means. So fair use is an affirmative defense to a copyright infringement lawsuit. And so when you're going through this entire process, you want to make sure it's clear from the very beginning, when you first do that dispute, that your video is fair use. If it's not fair use, then you probably don't want to go through and dispute all this. But Rick says, if you are an LLC, can you still have personal loss from a video about God first? I'm not sure what you mean, Rick. Kim says, so basically saying that if it's a major corporation, they are much more likely to take you to court. Thus, it's much riskier to mess with a large corporation than this. No, I'm actually not saying that. I think what I'm saying is I believe in looking at everything that YouTube has written about all this, they clearly are thinking about this from a perspective of a larger corporation, i.e. record label or a movie studio, because there's very little information about what the creator's rights actually are. And they don't do a good job of explaining your rights and what you can do. And just so you understand how much power you have, I actually think a studio is probably less likely to take you to court than now they'll be positioned to do so should they want to. And I think that if your video is not fair use, then they probably would take you to court, because they're going to have the copyright in place. So they're going to be able to act quickly. They're going to have the lawyers in place, and they would be entitled to statutory damages and attorney's fees in all likelihood if they went to court. I think you're more likely to have problems with the creator that doesn't know what they're doing, but maybe they do have a copyright registration in place for their video. But again, at that point, still, they're going to have to pony up some money for a lawyer, because these things are, like I said, copyright lawsuits and litigation, that is not inexpensive. That's very expensive. John says, will there be an issue using sports clips from NFL or other sports leagues? Yeah, that's copyright. That belongs to somebody. So you have to be making fair use of it. So, you know, I'm not going to comment on a case-by-case basis. That's the way the copyright law works. It's a case-by-case basis, and you're going to look at it and say, is this fair use or not? So whether you're using a movie, whether you're using sports clips, whether you're using news coverage, whatever it might be that you're using, you have to that use has to be fair use. So let's talk a little bit about what the factors are for fair use. So the first factor is the character and purpose of the work, and really this is kind of the biggest factor. In reading some of the cases about this, in preparing for this call today, your work must have what's called a transformative purpose. So you can't use the exact same work for the exact same reason. So if I were to take a big long movie clip and post the entire movie to my channel, and at the end take 2 minutes and be like, well, that was a great movie, I think you should check out that movie, that is not transformative, right? And even though that might be a reaction video, by definition, you're really not transforming the work. So what happened in the H3H3 case was, so Matt Hassanzada had created a video where he was this fictional character that he said kind of is somehow related to. I don't recall exactly. I think it's the person he maybe would want to be, but is not. So it's this fictional character, and it was bold guy versus, I think, parkour girl, and what happened is he chased her. There was some discussions at the beginning, then he chased her around, and the Kleins basically took a portion of that clip, that video that was about 5 minutes or so, and they stripped it out, and they gave commentary at various stages of the clip. So after the initial stage, they would go in and say and talk about it. They poked fun of him a little bit, and they basically commented on the entire length of the clip. And that was the transformative purpose, right? That they were changing it from this clip about this character, bold guy chasing a woman through the streets, into a commentary on why that may or may not be appropriate, and basically poking fun at the character as well. So that was the transformative purpose. And so you need to really be adding extensive commentary or criticism to the work. Parody is okay. Parody is a little bit different, but parody is where you are changing something about the work for greater social, to make a greater social commentary. Kim says, thanks for the great explanation. If someone sues you for copyright infringement, but it's pretty clear the video constitutes fair use, do attorneys ever work on a contingency for the defendant? I don't think so. What happened in the Klein's case is they could not afford to hire a lawyer to do all this for them. So, but a number of creators realized that that they had a good lawsuit, and that this is really important that this case be heard. And so I think some people set up a GoFundMe for them that got their attorney's fees paid for, but it was in the hundreds of thousands of dollars. And that's what makes all this so scary. It's not just the copyright strike issue, it's the copyright infringement issue and all these things. I mean, it's a very scary thought to go through all this. So anyway, back to the fair use factors. So the first thing is the work transformative? In other words, does it somehow add extensive commentary or criticism or teaching or something to the work? The second factor is the nature of the work. Is it factual? Is it non-factual? Is it published? Is it non-published? And this factor is, in the cases I've read, is typically diminished a bit. In other words, it's not as important to the overall determination. And none of these factors alone is dispositive as to whether or not the video is fair use or not. They just all can be interpreted differently by the courts. The third factor is the amount of the copyrighted work that is used. So you should be using the minimum amount that is necessary to convey your comment. Now, some use it has to happen, because without using the work, you can't really comment on the work or provide that criticism or teaching or whatever it is you want to do. What I'm saying I want to do with my videos is, like, let's say, watch a bit of a movie, and then comment on what the character has done in the movie, in terms of, if they were my client and I was the lawyer, how would I counsel them? What would I be telling them to do, or what would I be telling them not to do? Um, and use it as a teaching moment. So that's the way I plan to do this. But you should only be using the minimum amount that is necessary. You shouldn't be using anything more than that. So, like I said, you don't want to copy the entire movie and then, you know, talk about it for 5 minutes. That would not make sense. But if you just pulled little snips of the movie here and there throughout the movie, and commented on them as you went, then that would be more appropriate. Kim says, was it a precedent-setting case? Yes, it was a precedent-setting case. And if you hold on a second, I don't think. Let me see. I'll tell you what the case site is if you want to read it. Um, it was. You can find it here. There's a story from the BBC. But it's from the Southern District of New York. It's a district court level case. It's not an appellate court. It's not a Supreme Court case, but it is very persuasive. Generic says, I got a copyright claim instantly during the upload process. The copyright owner would allow me to use the video, but only if the copyright owner could monetize it. I deleted the video on my fine. You didn't get a takedown. Generic, you in all likelihood got a content ID claim. Go back and listen to the very beginning of the video today, because I talk all about what that means and what the implications of that are at the very beginning. So where were we? Oh yeah, the fair use factor. So that's the third factor. So we've gone through. So transformative purpose is the first factor. The nature of the work is the second factor, which is usually a minor factor. The third factor is the amount of the copyrighted work that is used. You should use the minimum amount that you need to use. People have said things like, oh, only use 3 seconds or only do that. Yeah, that's garbage. That doesn't mean anything. There's nothing like that in the law. And then the fourth factor is the commercial impact or market harm. Basically, have you usurped the original market for that work? So it is your video that you posted. Are people now watching that instead of watching the original video in place of the original video? And you have to be careful with that, because when you comment, you can comment and criticize a work, and it might actually decrease the market value for that original work, but that's okay. Like that's the way the First Amendment works here in the United States. It's where you are using the original work in a same or similar fashion, and then you're kind of usurping its value. That's where it gets to be problematic. So Ken says, I see people sell inspired t-shirt like Loki or Pokemon. Are those copyrighted even though they are not official or authentic? So yeah, I would say so. If there's a drawing from Pokemon, I mean that's probably problematic. They need to have a license to do that or permission. That's not really fair use. Again, everything, when it comes to fair use, everything needs to be interpreted on a case-by-case basis. And I'd have to look at the t-shirts and see. But so a couple practices, if you're thinking about uploading videos and you're thinking about using other people's content in a way that you believe is fair use, I think you need to do a couple things. I think you should go back and rewatch this video, because I go through the entire process from A to Z at the beginning. I think you need to consider using some sort of disclaimer on your videos that says that the non-licensed clips are used for fair use commentary, criticism, educational purposes, etc. And then you can include some case sites to like the Hosanzada case. There's another case, the Campbell case that deals with Two Live Crew using Pretty Woman in their lyrics. And then there's the Equals 3 case. So there's a number of cases out there that you might want to consider citing to in your description. And then I would encourage you to create a plan. You need to understand what fair use is and what it isn't. So, either talk to a lawyer, explain to them what you're trying to do. There's a number of lawyers that you can consult with on this. Or you may want to just place a lawyer on retainer to handle your disputes if you're not comfortable doing it yourself. Because understand that in all likelihood, you're going to get a content ID claim on your channel. And if you decide that you want to dispute that and take it, all the way up, then you might want to have somebody help you along that way if you're not comfortable with it. So that's kind of and I think overarching all of this is making sure that you know what you're doing and making sure you understand what fair use is and what fair use is not. If you're just stealing people's clips and putting them in your video for, background music or for whatever reason, that's not fair use. You need to make sure you get permission or get a license to do that. That's why I recommend, websites like Epidemic Sound or licensing the videos or the images that you use on your website, B-roll, stock B-roll, things like that. Because then at least you know that you're not going to have an issue with fair use. All of the music that's on my channel is from Epidemic Sound that I pay a license for each month. Also, YouTube has free resources for people for music purposes. But if you're going to do reaction style videos, it's going to depend on how much reaction there is in your video, how much commentary, how much education are you doing, different things like that. Let's see. Yeah, so that Lisa Dawn says, I know people who make and sell these types of fan-made products and they get cease and desist letters all the time. Yeah, I'm not surprised. I know an attorney that used to do these, and they would basically send out demands and they'd ask people to, take down the product and pay them a monetary fee, and that's what they did all day, every day. Kenneth this says, so another YouTube channel I watch called New Rockstar sells low-key inspired shirts. Isn't that copyright? I mean, I don't know. I'd have to see it, but it very well could be. The other thing is you often don't know what's going on behind the scenes, right? So if there is another channel out there that's doing reaction videos, you don't know. I mean, maybe they're doing their reaction videos and the rights holders are filing content ID claims on them and they're getting demonetized, but they don't care because maybe they're selling other products on their channel. Maybe they're selling other services on their channel, and maybe they're completely fine with the AdSense revenue isn't that much anyway. And so they're fine with somebody else taking their AdSense revenue each month. The issue becomes when you want to actually, not allow that to happen, right? Kim says, yeah, I bet those letters are really scary looking. They are. They definitely are. I've seen them. I've had clients that have received them. So yeah, I mean, I'm not going to sit here and say this whole process isn't scary. But what I do want you to take away from this video today, and I'm going to wrap up here in about 5-10 minutes, is that you do have more power than you think to handle these type of issues. And it's just a matter of understanding what the rules are, what you can and can't do, and understanding how the process works. And if you do that, you're going to be okay. And if you play within the rules, you're going to be okay. But if you're stealing people's content and posting it there and trying to claim it's fair use when it's not, then you're not going to be okay, because then you will get sued. And and you will get copyright strikes, and you won't be on YouTube very long. So there's a difference. There's a difference. And the reason why I think this is important is because I want to empower creators to put more content out there, to um, to get out there and be more creative. That's the goal, right? That's why we live in this country. I did see a question here. Supreme Prolific basically asked a question about LLCs. I'm not really going to get into that today, but yeah, if you're the sole employee, yes, you can file an S corp. Let's see, another question here. I was just watching your LLC videos. I'm not sure how to answer that question. Kim says, I need to hire a lawyer here in California to help me with copyright stuff. And what documents will protect my LLC and contracts? How do you recommend I find one? Well, you're talking to one, Kim. You can reach out to me at www.hawthornlaw.net, and if we can help you, let me know. We do copyright stuff, we do LLCs, we do contracts, we do all those things. We've got contract templates on our website. We've got some courses as well. Yeah. So, if you just need somebody to help you set up your LLC, that's something we can do. Trademarks and copyrights are both federal practice areas, so you don't necessarily need to have a lawyer in California to do that. Also, contracts, a lot of contracts like terms of service and website terms of sale and privacy policies, things like that. They're just going to be general contract principles. So don't necessarily have to be practicing in those jurisdictions. Same with Arizona, yes, for the person that asked. So, yeah, I'm licensed in North Carolina and Florida, but I help clients all over the country. I've set up LLCs in I don't know how many states. I also have a DIY service and things of that sort. So, and we just recently released I wasn't going to get into this today, but I might as well post it since people are asking. If you go to this website, I'm in the process of beta launching a new course on how to set up an LLC, and this will work for all 50 states. We actually have a database in there that we're still building out. But we have a database in there of of links that for all 50 states showing you how to set up your LLC, if that's something you're looking to do. But in terms of copyrights and YouTube, like I said, what I really want you to take away from this today is that you don't have to be scared. I realize it's scary. I'm not going to say it's not, but you don't have to be scared. You can absolutely fight within the confines of the system and win within the confines of the system. How about the use of things like logos, memes, and things of that nature in the thumbnails and videos? I know using a copyrighted photo and a thumbnail can result in a claim. Hello from Raleigh. Hello from Raleigh. Yeah, I think it's the same thing. It's fair use. I've seen lots of creators do this, and they wouldn't still be doing it if they were getting copyright strikes on their channel. So I believe, again, if there's a fair use of the image, then you should be okay. Obviously, if you can find an image that is that you can license in some way, that's going to be better. That's always better, but that's not always possible. And I don't like to. That's a really tough question. I'm going to leave it at that. But yeah, that's a tough question. So, what other questions do people have? I'd be happy to try and answer as best I can. And if we don't see any more, Lisa says, I'm here to ask the tough ones. Yes, clearly. I like the glass of wine. Can you get a copyright claim for the words used in a voiceover, not the video or the music, but if you read from someone's article, for example? I mean, again, it depends on if it's fair use or not. If you're doing commentary, then and reacting to what's in the article, then I think that's one thing. If you're just reading it to provide the same news that's in the article, then that's something completely different. I love your logo. Can you recommend a graphic artist? Yeah, I just did mine on Canva several years ago. I need to do a new one. But I did mine on Canva. There's a number of services online that will do it for you. It's been a while since I've looked at that. Let's see. What other questions do people have? Do people like these Friday Q&As? Because I'm gonna try and do more of them. I'm actually working with a strategist from YouTube. It's when your channel gets up over 100,000 subscribers, they invite you to apply to work with them one-to-one. And so you get assigned to a strategist / coach who will help you. And the coach that I was assigned to is basically telling me to do more videos, that I need to do more videos. So doing more lives is one way to do that. Kim says, this is so helpful. Thanks for this good talk. I have to go now. Well, thank you, Kim. I appreciate you being here. And Seamus says, yes, thank you. I appreciate that, Seamus. So, yeah, I think I'm going to end the broadcast at this point, but hopefully you found this helpful. Thank you so much. Don't forget to subscribe and let me know if you've got other questions or other topics. That leave comments below about things that you might want me to do on future live videos. But this is fun, so we'll see you next time. Take care, folks.